Hi, everyone. I'm Nathan Cortez from SMU Law School here in Dallas, where I teach health law and food and drug law and focus on regulatory theory. So I'm developing an article with Bill Sage of Texas on the artifices of corporate speech, and we tackle corporate and commercial speech. And our inspiration was that we noticed that the Supreme Court has been applying doctrines and theories and presumptions that were designed to protect core political and religious speech and using them in corporate and commercial contexts. And we think this has potentially dramatic consequences for our ability to regulate, particularly as we move more and more into an information-based economy. So Bill and I are both interested in information-based regulation, such as mandatory disclosure laws. And given how information-based our economy has become and how much information-based regulation makes sense with our modern economy, we worry that First Amendment claims will make it difficult to regulate going forward. Here's the First Amendment. It says, Congress shall pass no law abridging the freedom of speech. The issue we have here is that the Supreme Court is creating barriers to effective regulation, and that we're returning to the Lochner era, where the court is invalidating fairly prosaic efforts at regulation based on freedom of speech, just like the Lochner court did using laissez-faire economics and substantive due process. Bill and I are both health law scholars at heart, and so we focus on a number of regulatory challenges in which regulators like the FDA and states have been hamstrung by First Amendment corporate and commercial speech claims. So on the top left, regulating pharmaceutical marketing has gotten a lot more difficult due to First Amendment free speech claims. The FDA has spent 25 years trying to figure out how to deter off-label promotion, how to prevent companies from marketing products for uses not approved by the FDA without violating First Amendment free speech rights. Likewise, states like Vermont tried to maintain the privacy of prescriber data against use by pharmaceutical marketers, and the Supreme Court declared that that was in violation of their First Amendment free speech rights. On the top right, hospital prices have been an issue for quite some time, and both CMS, the Centers for Medicare and Medicaid Services, and states have tried to bring transparency to hospital pricing, but this has drawn First Amendment claims from the American Hospital Association, which argues that mandatory disclosure of hospital pricing violates their free speech rights. Finally, we have almost a 10-year saga with graphic tobacco warnings, where the FDA was directed by Congress under the 2009 Tobacco Control Act to require graphic warnings on the top half of cigarette packs, but the FDA's effort, its first effort, was invalidated under commercial speech claims by the tobacco companies. And it's taken the FDA almost a decade to propose new graphic warnings and to put them in place. So we've lost almost a decade from what Congress wanted to accomplish, to warn people of the dangers of smoking, because of First Amendment claims. And Congress realized that most people ignore the bland black and white Surgeon General's warning, and we need to catch people's attention at the point of sale. We also worry that these arguments are stretching further and further. And so you've seen arguments both from companies and lower courts and from scholars who argue that artificially generated speech or robotic speech should be protected under the First Amendment. And we worry that if courts accept that invitation, that it will become harder for the FDA and states to regulate medical algorithms and search engines. And so our general concern is that we have a modern information-based economy. A lot of modern regulation is based on mandatory disclosures and information quality control, ensuring that consumers and investors get accurate and truthful information from companies, and that these efforts will be considerably more difficult if courts accept these invitations to extend free speech claims in unnatural, aggressive ways. So I'm particularly proud of this graphic, which kind of demonstrates the dynamic here, which is that courts have used doctrines that were designed to protect core political and religious speech and applied them in the corporate and commercial contexts where they make no sense. So for example, there is a skepticism and a presumptive invalidity of content-based distinctions. We don't want the government regulating speech based on its content, but a lot of commercial regulation is indeed based on its content, and rightly so. The FDA cares what drug companies say about their products because they have overwhelming financial incentives to exaggerate the benefits and downplay the risks of pharmaceuticals. We don't care what doctors and scientists say because this is medical and scientific speech as long as the doctors and scientists aren't speaking on behalf of the company. Speaker-based distinctions, likewise, are necessary for modern regulation, but the Supreme Court would apply a presumptive invalidity to speaker-based distinctions. And so you can think of countless examples where regulation requires content and speaker-based distinctions, but the Supreme Court has cast a doubt on all of those through its aggressive use of the First Amendment. Moreover, the Supreme Court has shifted the ground underneath our feet regarding whose interests count in corporate and commercial speech cases. So when the Supreme Court originally granted protection to commercial speech in the 1976 Virginia Board of Pharmacy case, it did so based on the consumer protection rationale, and that it was the interests of listeners and consumers that mattered, rather than the interests of corporations as speakers. But gradually, the Supreme Court has started to recognize or adhere to this idea that speakers have their own valid interests under the First Amendment, which again treats corporations and artificial entities like natural persons, and we think that's wrong. And we also see cases valuing the information for its own sake. And so we call this a disembodied First Amendment, where you don't have any natural persons speaking and listening, but the court is valuing speech by artificial entities. And again, we think this has potentially dramatic implications, and we worry about our future ability to regulate. So this is what we attempt to cover. We looked at how this happened. How did we get to the spot we're at now, where you have presumptive invalidity of a lot of modern regulation that makes content and speaker-based distinctions? And we call these the artifices of corporate speech. And in part 3, we offer ways to properly reclaim the First Amendment from corporate and commercial interests that are swallowing it. So I look forward to the workshop and receiving comments. Thank you.